Hi, everyone. As we're waiting for people to join, please feel free to introduce yourself in the chat. You can tell us your name, your title, and where you're joining us from today. We'll get started in about 1 more minute. And again, I just want to I want to welcome folks and encourage them to introduce themselves in the chat. You can share your name, your title, and where you're joining us from today. And Danny, who is helping us behind the scenes, is going to launch a poll just to get a little more information about who is in this virtual room with us today. So this poll is anonymous and it is optional, but we would love if you would tell us if this is your first live Legal Network for Gender Equity webinar, if this is the second time you've joined us live, or if you've attended 3 or more. We would love to see who's in the room with us today. Folks, about another 30 seconds to answer our poll. All right, Danny, can you share those results so we can see who's with us today? All right, great. It's a sort of an even split. So, or not quite so even split, but there is a split in the room. So about half of you, this is your first live webinar with the Legal Network for Gender Equity. So thank you so much for joining us, and thank you to those of you who have attended before. It's great to see some familiar names in the chat. So again, welcome everyone, and thank you so much for joining us for today's Legal Network for Gender Equity webinar, The Rise of Anti-DEI Litigation and Legislation and Its Impact on Employment Law. I'm Lizzie Vogel, Senior Counsel at the Times Up Legal Defense Fund and Legal Network for Gender Equity team at the National Women's Law Center. I'm thrilled to be welcoming you all to learn more about this really timely and important topic that I imagine is very relevant to many folks in our audience today. And before we dig into that content, I just want to extend my sincere thanks to those of you who helped make today possible. So thanks to all of our attorneys in the Legal Network for Gender Equity for being here today and all the work you do on behalf of survivors. Thank you to my colleagues at the Law Center, Danny Stewart and Jennifer Mondino, for your help with today's webinar. And thank you to our fantastic presenters, who I will have the pleasure of introducing you to shortly. A few housekeeping notes. So this webinar is being recorded. We will share this recording and the slides from today on our website within the next few weeks. As always, you can find these webinars and other resources on our website at the link that Danny will add momentarily to the chat. And throughout today's presentation, we will have several polls similar to the one that you just saw. They are optional and they are anonymous, but we do hope you will participate. We will also have the chat function and the Q&A function available, but we do ask that you hold your questions until the end, where we'll have some dedicated time for Q&A. Danny, when you have a second, can you just make sure the slide for our agenda slide is showing? Thank you so much. All right, so just a quick rundown of our plan for today. So we will start with introductions, then we'll have our first speaker talk about affirmative action and race consciousness, Jinhee Lee, particularly in light of the recent Supreme Court decision, Students for Fair Admissions v. Harvard. Then Sunu Chandy and Emma Leibowitz will share more about attacks on diversity, equity, and inclusion initiatives in the workplace and beyond. And then we'll conclude with a presentation from Subha Bolini about legal framing for common patterns of workplace bias. So next slide, please. There are many impressive things to say about our speakers, but I'm going to keep these introductions brief and introduce them in the order you'll hear from them today. A longer bio for each speaker was sent out by email and will appear briefly on the screen. First, I'd like to introduce Jin-Hee Lee. Jin's the Director of Strategic Initiatives at the NAACP Legal Defense and Education Fund. Among her many impressive achievements, Jin led LDF's representation of a multiracial coalition of 25 Harvard student and alumni organizations, which served as amici in both the trial and appellate levels in the affirmative action case, Students for Fair Admissions v. Harvard. Next, I'd like to introduce Sunu Chandy. Sunu is a civil rights attorney and senior advisor with Democracy Forward. In addition to being a civil rights expert, she is also an award-winning poet. Some people really can do it all. Next, please welcome Emma Leibowitz. Emma is a legal fellow co-sponsored by the Harvard Law School at Democracy Forward. Emma brings a deep commitment to civil rights, honed in law school, to this work. And finally, I'd like to introduce Suba Bolini, a partner at Correa and Puth. Suba is a deeply experienced and widely awarded employment discrimination attorney, and her firm is actively engaged in our legal network for gender equity. So now I will turn it over to you, Jin, to get us started on part 2.
So much, Lizzie, and thank you so much to the National Women's Law Center for inviting me to be a part of this amazing presentation. I'm really excited to hear from the other speakers as well. And I am incredibly excited to speak to so many of you who are kind of dealing with the aftermath of the affirmative action decision from last year and its ripple effect in other areas, including employment law. I do not have expertise in the employment space, but I did think that it would be really important to explain some of these the reasoning of the affirmative action decision, as well as how some of the chilling effect is really based on inaccurate understanding of that decision from last year. So the title of the presentation is Affirmative Action in the Battle for Race Consciousness, because we at the Legal Defense Fund really see this as a battle of two worldviews, one which is inaccurate and kind of ahistorical and somewhat divorced from reality, which is a sense that we live in a world where all things are equal, and that any efforts to advance or to remedy systemic inequalities and self-discrimination. And that, of course, applies to race discrimination, but also gender discrimination as well. So, so first, let me talk about the affirmative action case. We at the Legal Defense Fund, if you can move to the next slide, we at the Legal Defense Fund, as Lizzie mentioned, had represented 25 student and alumni organizations from Harvard in the Harvard case from the very beginning. At trial, we presented witnesses, we presented evidence. We were involved in closing and opening arguments, also in the First Circuit Court of Appeals, and this amicus brief in the United States Supreme Court. The reason why I just think that it's so important to talk about the students and alumni from Harvard is that because they are the ones that are really the experts as to the educational benefits of diversity and the need to have diversity, to have the benefits of the world-class education that Harvard is supposed to be providing. And a lot of those stories were really ignored certainly by the plaintiff, but it would be really the litigation really relied on the university from providing those stories, and we felt it was really important to share those perspectives. And I think one of the most stark examples of the need to have these stories was the argument in the Supreme Court itself. Because if you're in the courtroom, which was a marathon argument that lasted almost the entire day, there was these questions about what is diversity, what are the benefits of diversity, kind of almost somewhat facetious, and yet outside the courtroom. There were outside the courthouse, there were all of these incredible students of all races, all backgrounds, really rallying to explain to the world, including the media, as well as the court, why diversity is so important to them. And I think that's important because most people in the United States think like they do, that they understand the importance of racial diversity, racial equity, diversity and equity of all kinds, obviously, the intersectional diversities that are so prevalent in our country and a great resource in the United States. So next slide. But the decision, which was quite devastating and really upended 45 years of stable Supreme Court law when it comes to affirmative action in higher education, that the decision itself was bad enough, but it wasn't as bad as many would like for it to have been. And so I want to kind of go through some of the myths that have been circulating in the aftermath of the SFFA decision. And I'm wondering if some of these myths might resonate with some of you, and that's going to be the kind of the subject of the polls in my presentation. So the first myth, if we can go to the next slide, is the idea that racial diversity was frowned upon by the Supreme Court. And that's something that I think has been seized upon in so many spaces, as if the Supreme Court was chastised the idea of having racial diversity, and that somehow that is something that whether it's in the workplace or in an educational setting, that is something that should not be pursued. And so that's, if any of you have heard of that myth, I think that's the subject of the first poll, if that's something that would be interesting to know from this audience. And here's the reality. Go to the next slide. The litigation around the benefits of diversity and the affirmative action cases in higher education really outlined what are those benefits of diversity, and some of this, even though it was targeted in the educational setting, has real relevance in the workplace setting as well. Preparing people to work in a pluralistic society, whether it's in education or whether it's in employment, that's something that's so incredibly important. Kind of interacting with people from diverse perspectives, having this exchange of ideas, broadening one's understanding, enhancing appreciation, respect, cross-racial understanding. These are all things that are so important in the educational setting, but equally important in the workplace setting. And so if we go to the next slide, you'll see that Chief Justice Roberts, in his decision, and he wrote the majority decision in the SFA case, said that although these, and referring to the educational benefits of diversity, he said, although these are commendable goals, they are not sufficiently coherent for purposes of strict scrutiny. So, Chief Justice Roberts is not disavowing those goals or criticizing those goals or saying that somehow they are not goals that one should aspire to have. In fact, he called them commendable. The point of his decision and the decision of the court is that those goals weren't sufficiently tailored or kind of cognizable to satisfy strict scrutiny within the analysis of the 14th Amendment. And of course, that's a very, very high standard. So there's a wide gap between saying that that the educational benefits of diversity or diversity on its own in other settings, it doesn't satisfy strict scrutiny, and what we often hear now, this kind of false rhetoric that diversity is somehow a bad thing and something that could actually be illegal. So I just really wanted to emphasize that there is nothing wrong with pursuing diversity. And of course, this is diversity of all kinds, and certainly racial diversity. Next slide. So here's myth number 2. It is illegal to know a person's race when making decisions. And this is one that often comes up and has come up actually among universities in the aftermath of the decision. And if we could go to the next slide. I wanted to point out SFFA, and SFFA, Students for Fair Admission, is a plaintiff in this case. And in their complaint, in their prayer for relief, that is exactly what they wanted. If you see the red arrow, they wanted a permanent injunction prohibiting Harvard from using race as a factor in future undergraduate admissions, but also conducting all admissions in a manner that does not permit those engaged in the decisional process to be aware or learn of a race or ethnicity of any applicant for admissions. So this myth is actually what SFFA wanted, but they did not get what they wanted. The Supreme Court did not go as far as granting what SFFA had initially wanted in their complaint. And in fact, SFFA realized how extreme this request was. They even backed away from this request during the course of litigation and also in the oral argument for the Supreme Court. So if you go to the next slide, and here's evidence of it, right? In his majority opinion, Chief Justice Roberts said that nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. So in his opinion, Chief Justice Roberts acknowledged that there may be situations where it would be perfectly permissible for not only for universities to know an applicant's race, but to actually consider it, consider the discussion of how a race affected the applicant's life. So there's nothing in the decision that prohibits universities, employers, anyone, people hiring anyone to know the race of the applicant. Now, this is something that has become quite controversial because in the aftermath of the decision, universities like Yale University, which was also sued by SFFA, changed its admissions process so that admissions officers would not know the race of any of its applicants. They kind of put aside all of their race data. And this has a real repercussions, I think, both in the university setting as well as in the employment setting, because of course, it's really important to gather data about race to understand if there's a disparate impact, if there are any kind of indication of inequalities. And so what I would encourage everyone to do is to continue collecting race data. There's nothing wrong about knowing the race of people who are applying for jobs or applying for admission to a particular university. What the Supreme Court said in terms of higher education is that you cannot consider race, like race cannot be a consideration in the admissions decision, but the awareness of race is absolutely not prohibited in this decision. So going to the next slide, and I believe myth number 3, it is illegal to foster diversity through race-neutral means. And if you could, and actually, if you once you answer the polls, it would be really think that I might be able to get some of the results. So maybe I will try to take the time. I'm actually new to using polls, and this is really exciting for me. And it's really actually very helpful to kind of hear or to understand, what the general kind of understanding is out in the world, because sometimes, I'm in my little bubble at the Legal Defense Fund. But yes, if you could answer whether or not you have heard or this is something that you've heard in circles or in the media or so forth, that it is illegal to foster diversity through race-neutral means. Myth number 3. And I will just say, if we can move to the next slide. This is actually an argument that is currently very much litigated in the courts. The Coalition for Thomas Jefferson High School is a group of kind of parents and concerned and individuals related to Thomas Jefferson High School in Fairfax County, sued the Fairfax County School Board. And I see the results actually for myth number 3. So most of you have not heard this, which is actually a good thing, but just so you know, this is actually something that is happening in litigation right now. And a lot of this litigation is being conducted by an organization called the Pacific Legal Foundation. And they have these kinds of litigation. Actually, I think we at the Legal Defense Fund are involved, I think, in 4 of their lawsuits that have been filed. This is one of them. We had filed an amicus brief, or we represented a multiracial group of of organizations that filed an amicus brief in this case. And it is a case that was brought against the Fairfax County School Board because of race-neutral changes that were made in the admissions process to apply to Thomas Jefferson High School, which is a very elite public high school in Fairfax County. And in Fairfax County, which is very, very diverse, very racially diverse, I think there's probably about 30 or 40% Black and Latino students in the entire county, and yet the racial demographics of the school itself is only 2% Black, well, was only 2% Black and 3% Latino students before the race neutral changes were made. And these are these are uncontroversial race neutral changes. For example, eliminating admissions test, eliminating the application fee, allocating, I think something like 1.5% of the seats to every middle school so that there would be a wider range of middle schools that could send students to Thomas Jefferson High School to have more geographic diversity, and also consideration of socioeconomic status, disability, language access, and so forth. And it actually resulted in some pretty remarkable changes. This is a typo here, but before the changes, economically disadvantaged students were only, it's supposed to be 0.62%. So that's 0.62%, which is less than 1% of the students were economically disadvantaged, and that jumped to 25%. And the reason why I pointed out that Asian Americans were the largest racial group to benefit from the increase in economically disadvantaged students is because the allegation in this lawsuit is that the changes were a form of race discrimination against Asian American students because the overall percentage of Asian American students decreased at Thomas Jefferson High School after the changes. It also, of course, increased the number of Latino students, but very modestly. It increased from 3% to 6%. It doubled, but it's a very small percentage. Black students increased from 2% to 4%. So this idea that race-neutral changes are somehow discriminatory is an argument that is being made by certain legal organizations and certain plaintiffs in lawsuits that are happening in various parts, all over the country, in New York City and Boston and Philadelphia, and this in Fairfax County. Next slide. Now, the reason why, one reason why many of you maybe did not think that this would be an argument that could be made is that this is completely contrary to the SFFA decision, because one of the arguments against having affirmative action, which is the explicit consideration of race, was the fact that governments and universities, that race-neutral alternatives were available, that you can still foster diversity with race-neutral changes. So, and we have that said explicitly by Justice Kavanaugh and Justice Thomas in their concurring opinions. We can move to the next slide. And finally, myth number 4, the SFFA decision changed the law pertaining to diversity, equity, and inclusion in the workplace. Now, this I would be really interested in hearing if you have heard this myth in your work or kind of in the media and so forth, because this is something that we've been hearing a lot of. If we can move to the next slide. I just wanted to very point out it's very obvious, but sometimes it bears repeating that the law is completely different between affirmative action and higher education, which the justification for that was the educational benefits of diversity. This is, of course, before SFFA, and affirmative action in the employment context. Different statute. It's also different justification. Never was, diversity ever considered a justification for affirmative action in employment. So we have two different areas of law, which is, is one obvious reason why the SFFA decision really should not have had an impact in completely different areas of law that has different kind of legal reasonings. Next slide. But what we are seeing is this incredible effort to use the SFFA decision and really capitalize on it and really promoting, again, this worldview that I mentioned before of racial colorblindness. And that I think is very dangerous, because it presumes that all things are equal in the present, and that any efforts to address inequalities or to advance some sort of equality would in fact discriminate against other people. And there's been a lot of focus on how this might affect efforts to advance racial equity, but certainly this is true for gender equity as well. In fact, all kinds of equity, because what this worldview really does is cement pre-existing inequalities as if they are the natural occurrence of merit and of people's, abilities and so forth, and that any effort to make changes to that would be detrimental and harmful to someone else. And so that is just something to keep in mind as we're making these kinds of arguments, to be very clear that no, this is not about the world being equal right now. This is about remedying pre-existing inequalities that have existed for not only generations, but as long as our country has been in existence. Next slide, please. And I see that half of the people did actually believe or have heard that fourth myth about the ripple effect of the SFFA decision, which is really interesting. I just wanted to point out this quote by Justice Jackson, which really kind of pulls together this notion of colorblindness. And she says it's very, very strong language with "let them eat cake" obliviousness. Today, the majority pulls the ripcord and announces colorblindness for all by legal fiat, but deeming race irrelevant in law does not make it so in life. And I really encourage people to read that dissenting opinion, because it's really, really powerful and just an amazing use of language in terms of explaining how illogical the majority opinion is. Next slide. So again, we've seen all of these attacks on diversity, equity, inclusion programs in the private sector. I know that there's going to be a lot of discussions about that later, but really kind of wanting to emphasize the fact that this is the reason why it is kind of coming in the wake of the SFFA decision, is because it's very consistent of the principles and worldview of the people who've been organizing and the principal architecture. I mean, the principal architects of the attack on affirmative action are also, this is kind of the worldview they want to impose in all areas of our society. And actually, we at the Legal Defense Fund have issued a guidance to kind of push back against some of these inaccuracies about the law and these attacks in the private sector, which I think will be in the chat. Next slide, please. And this is also happening in higher education with these anti-DEI laws. We actually, in the aftermath of the SFFA decision itself, we, along with some civil rights organizations, issued a guidance for higher education, because this is not just about admissions, but also about students of color being, their inclusion and equity once they're in the university setting as well. And so I really encourage people to read that as well, because that also gives an analysis of the SFFA decision. And the next slide. And finally, I just wanted to emphasize that despite all of this chilling effect and this incredible number of lawsuits that are being filed, to not be dissuaded by them. It's not a coincidence that all this is happening shortly after the largest civil rights demonstration in our nation's history in 2020, in kind of protesting systemic anti-Black racism, exemplified by the murder of George Floyd, and really emphasizing that racial equity is a moral and legal imperative. It's a legal imperative because our laws require it. That's why we have Equal Protection Clause, Title VII, and so forth. But it's also a moral imperative, because this says something about what we believe our multiracial democracy should be. What should our boardrooms look like? What should our workplaces look like? What should our classrooms look like? And something that we should all be committed to really pursuing. And I believe that is the end of my presentation. Thank you so much. This is a website we have. LDF has an equal protection initiative, which we launched to kind of address many of these issues. This QR code will take you directly to that website. I really want to thank again the NAALC for inviting me to this webinar, and I will now, I think, hand it off to our next speakers. Thank you so much.
Okay, I think we're on. Emma, are you on? Yes.
I am.
Awesome. Hi, everyone. Sunu Chandy with Democracy Forward. Thank you so much to Lizzie and the team at the National Women's Law Center. It's wonderful to see familiar faces, and I'm here from Democracy Forward. I'm there as a legal advisor, and I'm joined by our legal fellow, Emma, and we're going to be going through some additional information. Always good to hear from our colleagues at LDF and our partners. And thank you, Jinhee, for your leadership in this work. So Democracy Forward is a national legal organization that advances democracy and social progress through litigation, policy, and public education and regulatory engagement. And we use the law to build collective power and advance a bold, vibrant democracy for all people. And I was at the National Women's Law Center and litigated with DF and came over just last fall. And we aren't particular issue-based or identity-based, and so can help partner with a range of advocacy groups to push forward the good. So a big thank you to my colleagues at Democracy Forward, because since the SFFA decision that Jinhee explained came down, there have been dozens and dozens of lawsuits filed by extremist organizations that Emma will explain in all different contexts. So in our slides, we're going to go through an overview of those contexts and then talk about how that's playing out in the employment law space. And so my colleagues, Meg Uzel, Brooke Menschel, and now Emma, have been doing a lot of work to track those cases and read them every week, because there are new ones every week, and to see what the trends are, who's bringing them, and how we can intervene, engage, file amicus briefs, and otherwise just be in community around fighting back against these attacks. All right, next slide.
Great. Well, as soon as said, it's so nice to be here today and to learn from the other presenters and to get the chance to sort of share some of our findings and what we're seeing with you all. As sort of Jin's presentation started to tell us about, the attacks on DEI have taken various forms. They have sort of crossed run the gamut from litigation to demand letters to state legislation, quashing DEI programs. And although the bulk of our presentation will focus on the litigation, which we sort of spend the brunt of our time tracking, we wanted to start by providing you with some context, because the litigation, the legislation, and letters and other sort of attacks on DEI are all sort of part and parcel of one really measured attack. So to give you all an overview, I'll just say currently Democracy Forward tracks about 50 plus cases that are attacks on DEI. Those challenges cross public sector, private sector, at the federal and state levels and beyond. And we'll get into a little bit more of that in the following slides. Now, as Jin also mentioned, we've seen in the past few years just a wave of anti-DEI legislation, largely targeting universities and other institutions of higher education. These laws have popped up in Texas, in Utah, Alabama, Florida. I think I saw that there was a Floridian, at least one on, Florida, I think, led the way with this legislation last year. And so, some of you on the call might be familiar with what these laws look like. But really, these bills, many more of which are in process, limit sort of the use of funding for DEI efforts at higher ed institutions and in other parts of government. They have led to a closure of DEI programs on campus. They also restrict the use of DEI statements or diversity statements in employment decisions. And these laws are really broad sweeping. For example, legislation recently enacted in Alabama, says that it prevents the promotion of divisive concepts, which makes them really broad and I think difficult for those impacted by the law to figure out exactly how they'll be impacted. Advocates are really considering ways to challenge the law, but it's hard to figure out how to attack these types of laws. And one thing I wanted to note is, although there are a lot of headlines about these laws, to the extent you all as practitioners are thinking about them, they are sort of limited in two ways. One is they're only in certain states, and although this map on the slide looks colorful, there's still states that are in the gray. And two, it only applies to certain types of employees. Lastly, we're seeing a number of letters from anti-DEI actors. These take many forms. They have been demand letters to private entities, the NFL one here is a great example. Letters from organizations such as America First Legal to the NFL or to Disney complaining of various practices. Simultaneously, these organizations have tended to send a letter to federal agencies such as the EEOC and then sort of proclaim a civil rights complaint has been filed, even though these letters have limited legal weight. Additionally, we've seen letters from state attorneys general to similar, corporations. Last July, I think about 13 state attorneys general sent a letter to the CEOs of Fortune 100 companies, citing SFFA, saying that racial discrimination by private companies violates the law, and arguing that or alleging that these companies were doing as much. And in particular, they'll cite many of the efforts that companies have made following, as Jen alluded to, the murder of George Floyd and subsequent demonstrations in 2020. Next slide. So, as I said, we're going to focus on the anti-DEI litigation in the rest of our presentation, and Sunu is our employment expert, so she will dive into all things employment, but I'll again just give some broader context to begin. This anti-DEI litigation, as you have can see on this slide, covers a broad swath of issue area. We have seen suits filed against private companies for grants that they provide. We have seen suits against the federal government for grants and their contracting system. We have seen suits to public boards, public universities. There's a case we track that has to do with continuing medical education trainings in California. So they really sort of run the gamut of different subject areas. And at DF, we really think about these attacks on DEI and pro-diversity practices as part of a broader attack on, I think, a multicultural society. So they're part and parcel with the limits on, K through 12 education curriculum and book bans and anti-LGBTQ+ litigation. So we really think of them as in tandem. And just to give you a sense of sort of the types of claims that folks will bring, obviously there's a number of different actors that are defendants in these cases. And so dependent on whether they are public or private actors, different legal claims may arise. This includes Title VII against private employers. I'll note, in particular, we have seen the rise both against state and local public actors and private actors of 42 USC 1981, which prohibits discrimination in contracting. This statute was originally passed immediately after the Civil War as sort of an effort to promote and support opportunities for formerly enslaved people, and in the 1960s was used to advocate for communities of color. It is an area with a sort of lesser developed jurisprudence than, say, Title VII, but it is being beefed up and developed as they come. And I'll note almost in every complaint we see, there is a citation to SFFA, whether or not it is legally relevant. So, before I hand it back over to Sunu, I'll just give an example of two cases that I think demonstrate the sort of breadth of these challenges. So the first is one you may have heard of or read about in the news in the past couple of months, which is called, Fearless Fund case. This is a challenge to a grant program that gives money to businesses owned by Black women. It's being sued by the same actors that brought SFFA on 1981 grounds. And they allege that this grant program, which is meant to boost, boost the visibility and participation of Black women in business, violates the law. And the case is currently on appeal to the 11th Circuit. It's at the preliminary injunction stage, but they appealed, and we are waiting for an opinion in that case. The second case, which we wanted to highlight, is a case in California State Court challenging the city of San Francisco's programs that give, grants or sort of direct payments to various types of, people, including grants for monthly stipends to pregnant Black and Pacific Islander women, an equity program that gives, guaranteed income for transgender people, which provides a monthly guaranteed income to transgender people that meets certain qualifications. And these programs are all being attacked in one lawsuit as violating not just the Constitution, the US Constitution and Title VI, but also the California Constitution by discriminating on the basis of race, ethnicity, gender, and sexual orientation. So I think that should give you all a little bit of a flavor of the broad scope of cases out there. And with that, I will pass it to Sunu with the next slide.
Thank you, Emma, for providing that context. So we wanted to go a little deeper into the employment law area. Many of you on the webinar may be experts in this, so bear with us, but I think some of these are just important reminders. And I saw that there was a question about sort of the attorneys wanting to shut everything down. And as I like to say on panels, this is the time for law firm attorneys and in-house attorneys to sort of do the good that they're there to do and to be very careful and nuanced about this work. So starting with programs and policies in the workplace, there are many ways to promote diversity and inclusion through the work that are fully legal. Job postings often send a message of inclusion or exclusion, depending on what kind of skills you're looking for. Sometimes postings ask for advanced degrees when it's not necessary. Sometimes postings ask for top ranked schools when we know that there are many barriers for those schools for many communities, and not instead of just looking for the skills that are necessary for the work. I also want to mention about data collection. I think Jinhee mentioned this. Voluntary data collection is so important, so you know who's there in your workplace, and so that you can provide that information to EEOC and to have self-audits and assessment of who's at your job, who's getting promoted, what are people getting paid. And speaking of pay, obviously putting pay in your job posting, I just messaged a friend on LinkedIn today and I said, I was going to post your paralegal job, but it didn't have the salary. And she said, thanks for calling me in. We absolutely will add the salary band for our paralegal. And that was for a progressive law firm. So we know not having salary information in job postings often perpetuates discrimination and sort of has women and people of color either not negotiating or being penalized when they try to negotiate their pay. So those are some ways where we can absolutely continue to advance diversity and inclusion. We can also make broad statements about wanting to have more diverse workforces in terms of race, gender, sexual orientation, disability, and all the different identities. And even though there are letters saying, oh, if you say that you want more women to be in positions here, then you're definitely discriminating against men. And there are complaints. There's actually a case that I just saw today about a man not getting promoted. And he said, it's because they have this program about they want women to get promoted. Employers can go around saying they want particular groups to be included and advanced and promoted, because as we know, a particular employment discrimination analysis has to be undertaken about someone who does not get a particular role. And there's so many facts that are in each of those situations. And just having broad statements about the mission and desires of a company to be inclusive on a number of fronts does not mean that someone who's not in that protected group is going to win their discrimination case. But I think a lot of companies are sort of overcorrecting and stopping all of those important statements. Now, in terms of a few good resources on the tons of ways you can continue to advance DEI, I would recommend the New York State Bar report that is put out by big, and it seems like about half of us have been approached on these questions because they are definitely in the headlines and on a lot of people's minds. So resources, the New York State Bar, which is, big law firms were involved in putting that together, big corporations, the LDF report that I think has already been shared, are all good resources about what kind of steps that can still be taken. And in terms of, in the academic context, there've also been some challenges with professors or others bringing lawsuits about what kind of statements they don't want to make, or if they're being evaluated based on DEI. And I think those cases are percolating and we'll see what happens with them. But I don't think that employers at any point need to correct and stop those kinds of programs. Now, when it comes to anti-discrimination training, which we know is vital in terms of letting employees know their rights and employers know their obligations, particularly when there are new protections like ones that the Law Center has been advocating on, like the Pregnant Workers Fairness Act and new protections, we need to keep these protections going. And at the same time, there have been challenges. There's a lawsuit saying I shouldn't have to take an implicit bias training and so on. So I wanted to recommend this amicus brief in VARA, this EEOC brief that we'll share with the resources, because it really lays out how training is important, courts approve consent decrees with training, and so on. I do want to highlight race-specific programs because those are a tricky area. However, they are allowed under Title VII, even though they are rare. And those standards were laid out recently in an EEOC amicus brief in Roberts v. Progressive. We'll send the link for that as well. And that's really important. That was a 1981 case where EEOC said the standards for race-specific programs should follow Title VII. So it lays out what's allowed under Title VII. But these are very, you have to have a record of discrimination and have to be narrowly tailored, and you can't totally bar other people from applying. And there were 3 law firm cases with minority type fellowships, and they've all settled. Thankfully, they've settled for criteria that I think will still help the law firms, seek students of racially diverse and other diverse backgrounds, but they're not race specific anymore. One of the 3 law firm cases was just saying it's a fellowship for underrepresented students in the law. So I absolutely think that was defensible, but we know that people settle cases for all different reasons. So I see we only have a few minutes left. So let's go to the next slide. I think Emma is going to maybe just talk really briefly in a couple of minutes about this slide and the next one, just to give a flavor of the kinds of cases.
Perfect. Yes, I will be quick here just to say, one of the types of cases that we have been tracking a fair bit at Democracy Forward are these challenges to board composition, which includes both the composition of, public boards, such as a state board of medical examiners, but also private boards. There's a case challenging a California law that requires public corporations in the state to have a minimum number of female and racially underrepresented people on their boards. So we wanted to share these cases. I won't run through them all, but they are on the slides for you, just to say this is another type of attack against DEI and against sort of multicultural society and representation as such that we have been seeing in this space. So we can skip through the next slide quickly, and hopefully that can be a resource. And if we go to the next slide, I will just talk a little bit quickly before I leave it to Sunu to close us out here. which is just to say, and Jin alluded to this in her opening remarks, regardless of the focus of the cases, it just turned off lights in my office. Okay, regardless of the focus of the cases or these letters or legislative efforts, we are seeing the same group of anti-DEI actors behind these attacks. They're not one-off cases, but they're a targeted approach. Jin mentioned the TJ case brought by Pacific Legal Foundation. These are attacks on DEI and education and diversity in all areas of life. Some of them have sort of carved out a niche for themselves in these challenges, which you can kind of see mapped out here, but they're coordinated, and the efforts are really working in tandem. And in particular, I'll just say, even where these areas are legally distinct, these groups are coordinated, and they are, working together and citing to one another as they jump between legal area and build the case law in the direction that they would like to. So with that, we can go to the next slide, and I will give it to Sunu to close out.
Right. So thank you. I see we only have a couple minutes. So I'll just say, this is an area where we have a lot of things happening at the same time. And we, I think, should be reassured that the vast majority of DEI related programs are legal. But as I said, in response to the question that came up, there do need to be legally reviewed, because I think there's a new spotlight, particularly on race-specific programs, and they need to be meeting either the Title VII guidelines or otherwise defensible. And, I feel reassured that we are all in this together and hopeful, because, big law firms, many companies, corporations are all sort of on this issue going in the same direction of knowing that DEI is helpful, and these programs and policies are helpful in terms of employee retention and all of the values that we're putting forth here. I'm going to put a case in the chat. When I said cases are getting updated every week, I mean that. This is one that we just read today, and it has to do with a man saying that he didn't get promoted because his employer had a program about promoting women, and so changed how they did their procedures. And so even though she also got high rankings, he thinks maybe he had a higher ranking. And so they're using this broad policy of inclusion to sort of challenge individual decisions. And as I said before, we don't know what happened in his particular situation, and that would have to be analyzed on the facts and should not be a reason to shut down really important programs. Okay, next slide. Okay, and these are just the resources that we will make sure to send along. If you just want sort of the basic overview, the president of Democracy Forward and I wrote this article for Bloomberg that's not behind a paywall. You're welcome to share that with colleagues and friends about, what's really still allowed. There are many, many ways that diversity, inclusion, and equity programs must continue. And a lot of this is a narrative fight, as Emma said. They're filing letters and calling them federal complaints and trying to sort of get the public to think that after the SFFA decision, that none of these programs are okay anymore. And we're all here to say most of them are. And for race-specific ones, you need to take special care. But there's so many ways that we can keep the fight going. Thank you.
Right. Thank you, everyone, for joining today. And thank you to the National Women's Law Center for addressing these important topics. It was really wonderful to hear from Jinhee, Sunu, and Emma. I have a lot to cover, so I'm going to dive right in. But I want to say thank you to Jimmy Stark, our law clerk, who's a student at Georgetown Law, and who assisted me a great deal with research to prepare for this presentation. Next slide, please. Right. So I think it's pretty easy after hearing from the other speakers to connect the dots as to what might happen. And I think I took notes on something that Jinhee said, which is that the potential of rolling back DEI programs will result in cementing pre-existing inequalities. So as I see it, that's reverting to the status quo ante. And so we're going to look at today what some of the types of employment decisions are that may be affected by bias in the absence of effective DEI programs, and that includes also anti-discrimination training. Next slide, please. All right, the piece of DEI that seems to be most directly affected when it comes to employee workplace experience is equity. And so for sure, increased diversity and inclusion, especially in the leadership roles, helps mitigate workplace discrimination, that kind of diversity at the top. But a lack of equity tends to lead to disparate outcomes more directly. So what's described in this Harvard Business School article here, this excerpt, is what an effective DEI program should achieve, in the sense that promoting equity is a means of preventing unlawful discrimination. So I want to add now that although the terms have been used quite a bit and have been in vogue at points as well, and used by courts also, I'm going to avoid using unconscious or implicit bias today in discussing the types of discrimination that employees face in the workplace. Okay, next slide, please. Now, I found extraordinarily helpful and relied a great deal for this presentation on the work of Professor Joan Williams, who many of you are aware of, you know of her work, you're familiar with it. She founded and recently stepped down from her position as director of the Center of Work-Life Law at UC Law San Francisco. And I'm going to discuss the approach to framing discrimination claims as laid out in her 2020 Law Review article, which she wrote with colleagues, and which I recommend everyone read. I think it's 120 plus pages, but just chock full of information and really great strategic advice as well. But I also found very helpful her 2021 book, which is written as guidance for employers, and that is called Interrupting Bias. And there's a corresponding website called biasinterrupters.org, which is a free online resource for employers. So, you know, we hope that employers are doing the right thing, and I think many of them are. And as Sunu mentioned, employers who care to take a rational and practical approach to mitigating unlawful biases in the workplace would rely on the type of information here that is on this website. And I think it's very helpful for us as employment lawyers, plaintiff side, to understand as well how the employers would approach addressing some of these issues, and maybe really what they should be doing as well. So let's assume that in the absence of an effective DEI program, either because the employer really never established one, or because in the face of this type of bullying from the right wing, it's rolled back its initiatives, we're going to see that certain employees are vulnerable to discrimination. And moreover, I think we'll probably see that the atmosphere of hostility toward DEI will leave certain employees who are perceived to have been hired as part of an employer's efforts to increase diversity. Those employees are also going to be vulnerable to discrimination. Next slide, please. So I just wanted to bring up very quickly the Muldrow case. And I'm not going to go into it. I think a lot of our colleagues are going to be doing presentations over the course of the next weeks and months discussing the impact of the case. Obviously, it's going to be very helpful to employees, plaintiffs, employment lawyers as well. But what I wanted to point out here is that as we're going through examples, I think that understanding the impact of Muldrow means that we can think beyond framing certain types of employer conduct, the types of patterns of discrimination that we might look at as just contributing to a hostile work environment. Because the previous standard for proving a discrimination claim, these types of discrimination may not have been actionable other than as part of a hostile work environment claim. But now we'll be able to look at certain actions differently and focus on whether the conduct was discrimination that causes some harm, as the Supreme Court framed the standard to be. All right, next slide, please. So just some quick thoughts on discovery. And while, while we're going through some of the examples, including some hypotheticals or examples of cases based on cases that I'm familiar with. We want to think about what are some good approaches to addressing the lack of effective DEI and how that has resulted in discrimination in certain claims that we might encounter. So one idea is to consider a rules of the road approach. And that is something that many of us may be familiar with. The book is Rules of the Road, a plaintiff lawyer's guide to proving liability by Rick Friedman and Pat Malone. Highly effective method developed by a couple of personal injury lawyers. And the method requires that a plaintiff's lawyer establish principles that both educate the judge and jury on the standards that apply to a particular field. And by establishing certain principles and getting an admission from a witness of an employer that these are principles that they or the company abides by, we can then convert this to a question of whether the employer in some way violated that principle. So for an example here, in the context of a bus accident case, child safety should be the primary consideration in any decision concerning student transportation. That's kind of a common sense principle that a witness may agree to, and that can be converted to a question that requires a witness to answer, yes, I agree that that is the case. So right now, I think we have employers who have DEI statements, some of which they have rolled back. And I think we can see that both through websites, 10K filings, etc. You'll be able to get that probably through discovery and find out, whether the employers still abide by the principles that they set forth as their own. And you can also look at some of the personal DEI statements that for instance, academic institutions, nonprofit organizations, and some other employers require their employees to draft. And so I think those are good sources of principles that should prevent the employer from engaging in discriminatory practices. So the other thing I wanted to focus on today is processes. So what are the decision-making processes that lead to discriminatory outcomes? And we're going to look at a few examples of that. How, if at all, were those processes infected by unlawful discriminatory biases? And so, where the employer was aware of a potential of bias or actual bias in the process, find out what those processes are for hiring, pay setting, performance evaluations, promotions, etc., and see if the employer failed to take meaningful steps, living up to its DEI principles, for example, to interrupt bias in the decisional process. So again, I recommend the Williams book as an example of some of the actions that employers can take. Was a known discriminator allowed unchecked decisional authority? Next slide, please. All right, so the Workplace Experiences Survey, WES, is something that Professor Williams and her team used as a basis for a law review article that I've referenced already. And what they did is boil down 40 years of lab and audit studies from social psychology, industrial organizational psychology, behavioral economics, and they distilled that into 5 patterns of bias that affect women and people of color. They then converted those patterns into a 10-minute survey. So each survey participant then, and there were over 5,000, I'm doing the math very quickly in my head here, 3,093 engineers, 2,800 some lawyers, science professors, architects, tech workers, and 25 other cross-industry participants answered questions about their workplace experiences. And what the surveys confirmed was that there are patterns of bias that are documented in lab studies that actually show up in workplaces today. And the data reveals a large divergence between the workplace experience of white men and that of other groups. Next slide, please. So the five patterns are identified. There are 5 patterns that are identified through the survey. I'm going to use the names that Professor Williams used in the article again. Prove it again bias is one. And I'm just describing them in a nutshell, but there are many examples of how this may manifest. But mainly, prove it again bias means that women and Black employees, potentially other minorities, have to provide more evidence of competence in order to be seen as equally competent. So we can look at this as a form of applying different performance standards for different employees. And that bias itself may be a reliance on a discriminatory stereotype that the woman or Black employee is less competent, intelligent, or hardworking. Tightrope bias, number 2. Imagine that certain employees are walking a tightrope that confines them to behave a certain way in the workplace to avoid being criticized. So certain behaviors, such as being assertive, promoting oneself, displaying emotion, behaviors that signal competence and mastery are acceptable when they're displayed by white men, but unacceptable from women and people of color. And so this is something I think that, you know, everybody knows Price Waterhouse as a landmark case exploring the double standard for workplace behavior. So these are the types of biases, again, that might be addressed by the training that's part of a DEI program. But you know, in the aftermath of a rollback, or if there was no program at all, we might see these resurface. Maternal wall bias, negative assumptions about a mother's priorities, tug of war bias, bias against a group fuels conflict within that group. So members of the group struggle amongst themselves as to whether to align or distance themselves, and sometimes end up discriminating for reasons that are described here. Racial stereotyping. This is something very common here, and just a few of the racial stereotypes. Asian employees are often expected to be hard workers, but are assumed to lack the skills or personalities that are required for leadership roles. Black and Latino employees characterize displays of emotion as examples of an angry Black woman or a hot-blooded Latino. And of course, there are many other such offensive stereotypes. And so what Williams recommends in her article is to cite to this type of the findings of this research as a legislative fact in a complaint. So plead that this is a commonly known now type of bias, and social science research indicates that these discriminatory attitudes are common and even typical in the 21st century. So the most famous example of judicial notice of these types of legislative facts was the Supreme Court's conclusion in Brown v. Board of Education that the system of separate schools adversely affected African-American children. Everyone knows it's true. And another thing to take note of as we look at these following cases is that Price Waterhouse, in Price Waterhouse, the court acknowledged that expert testimony is not needed where a type of bias is commonly known and understood. Okay. Now, next slide, please. So I have a poll now, and I would like for participants to answer. You know, if you identify as a woman or a person of color, first of all, and if you answered yes to question 1, during your career, have you experienced any of the 5 types of biases? Right. And so what was particularly interesting, I think, was seeing this, asking this question, or even just describing the biases when we were in, you know, talking about a similar subject at a recent ABA conference, because what I was seeing was a lot of nodding of heads in the room as I went through. And these were not all plaintiffs' employment lawyers. They were, you know, people from in-house and corporate counsel as well. So people's personal experiences, I think, do match up to the research results from the WES. All right, so I'm going to go on to a fact pattern here. An employee is a scientist at a research institution. And research has shown that women in scientific research positions in academia and elsewhere face discriminatory barriers to advancement. Let's see, the poll results. Yes, 80% are women or people of color on this webinar, and 70% have experienced prove it again bias, 60 tightrope, 35 maternal wall. Wow. And that's somewhat depressing, but not surprising at all. So our own small sample size here confirms what the workplace experience survey says. Thank you, everyone. Now, going back to the fact pattern, the scientist was denied a tenured position, or at least her supervisor refused to recommend her after taking the following actions. He says after she is a child, he questions her commitment to a career in research, describes her to her male colleagues in assessments of her professional development as being rough around the edges, overly ambitious, and having a strong personality. He downplays the value of her research, which is focused on women's health, and he denies her funding based on his assessment. So setting a bar for tenure, he says that if she gets her work published in a prestigious scientific journal, then he'll recommend her for tenure. But he adds a new requirement then, which says that after she does get her work published in a prestigious scientific journal, he adds a new requirement. So that's not enough for tenure. And then he alleges that she committed a serious infraction that warrants termination, subjects her to an investigation. And at the same time, turns out doesn't investigate the male scientists who were involved in the same research with her. All right, so I selected this fact pattern because it involves performance assessment, which can often be difficult to challenge. Several types of complex decisional processes are also at play. Evaluations of scientific research, evaluations for tenure, for non-compliance with research protocols. And so the key is to find out what part of each decision-making process is subjective, and therefore where the discriminator's bias can affect that process and result in a discriminatory outcome if unchecked. So going through, we kind of saw a lot of the examples of the types of biases that were named through the workplace experiences survey. So maternal wall, prove it again, and tightrope, all of those. Okay. So it looks as if I have nearly run out of time. So I wanted to just get to, a couple of cases here. Next slide here. Let's go to, Margolis v. Tektronix. So just as an example here, the Margolis case tends to shows that an atmosphere of gender discrimination in which a jury may find that that discrimination tainted the layoff decision. So Margolis' supervisor selected her, a 15-year employee, for layoff based on relative score on a skills matrix, which her supervisor himself had prepared as part of the layoff process. The matrix suggested that Margolis had inferior qualifications and skill sets as a manager. Now, Margolis presented evidence of a record of good performance, both through her own testimony and that of another supervisor. And however, the supervisor who selected her for layoff would rarely hear women in staff meetings. He gave her inferior work assignments. And he said that her supervisor had told her that others considered her pushy and aggressive. And she supported this by pointing to comments in an earlier performance review. Next slide, please. So what the court said here is, while her supervisor's comments might not have been as blatant as the sex stereotypes in Price Waterhouse, the subjective nature of the skills matrix prepared specifically for the workforce reduction left ample room for such stereotypes to affect Margolis's scores. So again, going back to fact pattern 1, the supervisor with the authority to recommend tenure followed a similar pattern. So again, using a subjective opinion of the value of research to limit resources needed for her to progress. Let's go on to the next slide, actually, and we have another case in which similar types of biases lead to a denial of tenure. I wanted to just jump ahead very quickly to one final case. If we could go to, I think, slide 58. All right, so this is a great racial stereotyping decision, and I can send out the cases that are in this presentation that we didn't get to, but prove it again, bias and racial stereotyping here leads to a denial of a raise. And this particular decision is kind of a plaintiff's employer dream here, because the court looks at the research. If you could skip ahead to the next slide, court looks at research of legal scholars who are discussing intersectional stereotypes of Black males in the employment context, and cites to these types of stereotypes, Black males being less intelligent than other groups, including Black females, and says that this type of stereotyping manifests in the conduct that the employer engaged in this particular case. And so this is just a wonderful opinion. So I highly recommend that you read that. And finally, the court described the supervisor's fixation with finding weaknesses in Kimball's performance. So the supervisor was just fixated on picking at everything that he did, his writing, etc. It was she viewed him as if he were veiled with images of incompetency. All right. So I'm going to leave you with that type of language and send along the other cases that we didn't get to cover today. But again, I would, in an ideal world, be happy if I didn't have a job to do, protecting employees from this type of discrimination by litigating their cases. So we hope that employers do rely on evidence-based findings, such as the Workplace Experiences Survey, and make a good faith effort through DEI programs to mitigate biases. But when employers don't do right by their employees in this way, either because of SFFA or otherwise, all of us have to continue to fight and use all the tools at our disposal, even if we're looking outside of traditional legal resources. All right, thank you again.
Thank you so much, Suba, for concluding our presentation, and thank you so much to all of our speakers, Jin, Sunu, Emma, Suba. Thank you for that deeply thoughtful and thought-provoking presentation. Jin, the point you made about this being not just a legal imperative, but a moral imperative really resonated with me, and is definitely something I'm going to take away from today. So we have about 10 minutes for questions, and we would encourage you to either add your questions to the through the Q&A function, especially if you'd like to be anonymous, which you're welcome to be, or feel free to add your questions to the chat. And Lori, yes, a copy of the slides in addition to the recording will be up on our website in the next week or so. Danny, thank you for reading my mind. So that's the link that you can find this webinar shortly. You'll find the recording and the links of this webinar on this link, and then all of our past webinars as well. So yes, please add any other questions to the chat or the Q&A function. And I wanted to start by, during the presentation, we had a question in the Q&A. Let me just pull that up. And I know that Sunu and Jin, you both had an opportunity to respond briefly in writing, but I did want to give you, I wanted to share the question with the entire audience in case folks hadn't seen it in the Q&A. And then I also wanted to give you, Sunu and Jin, and Em and Suba, if you also want to chime in with anything, just give you a chance to elaborate if you wanted to. So the question was, a lot of the chilling effect in workplaces is actually being led by general counsels and law departments themselves, who leverage this moment to extend their own influence. We're dealing with lawyers wanting to review all DEI training curriculum, which will absolutely hinder the work. What advice do you have for them? So Sunu, I'll let you start if there's anything you wanted to add to your written comment.
Right. I do recommend having that review happen, because after SFFA, even though the decision was about different interests and laws, it has put a spotlight on any and all of these programs. And so you want to make sure that you have programs that are legally defensible, or if you're going to be taking risks, that you know what those risks are and you're doing it intentionally. So even though it slows things down, I would say having an employment lawyer, having an expert look at the materials is important. Now, what I think is embedded in that question is like, they just want to, influence themselves, and maybe they don't share the same agenda and interests. And if that's the case, I think that's a moment for internal advocacy. And as Jen said, so importantly, so many of these programs only were developed or strengthened after Black Lives Matter, and so much advocacy by mostly Black people in this country to push this very important mission forward for racial equity that's long overdue. And so just when these programs, and I could say the same about Me Too, and just when these sort of movements are happening that can lead to better, important, increased programming in these areas, is not the time to shut it down. And so if it's an internal advocacy issue, I would take it up on that side. But if it's really just the lawyers there need to make sure that the company is doing what it can to have legally defensible programs, then I think that's also important to do as well.
Thanks, Sunu. And Jin, did you want to add anything to build on the written comment that you added?
Yes, I completely agree with Sunu about, a lawyer's job is to make sure that, their client is, kind of abiding by the law and to address issues of liability. And that's the assumption, I think, in the question, is that there's concerns about potential liability. The point that I, had made in my comments, and I think it bears emphasizing, is that there's a lot of, there's a big spotlight on potential liability from these lawsuits that are being filed by these very extremist conservative organizations. And I have to say, many of these lawsuits don't even, kind of pass a motion to dismiss. Some of these lawsuits or complaints and so forth have been frivolous. But, understanding that is, a genuine concern that many law departments have, there is also potential liability for violating, Title VII and 1981 for not, for having unfair barriers for women, for people of color, for LGBTQ plus individuals. And I just really want to emphasize that there's going to be heightened scrutiny, of businesses that have very undiverse workforces and perhaps no justification for that. And I think that there's a real need to understand that there's a liability on that end as well. So it's not as if that we should just be that businesses should just be concerned about lawsuits from these conservative organizations, but also there are potential lawsuits or actions by the EOC or plaintiffs and so forth, or plaintiffs or lawyers and civil rights organizations, if there's real problems in terms of the equality within the workplace. So and that should be considered by in-house lawyers as well. And the recommendation that I had is, there's so much scrutiny and so much examination of, for example, the DEI training programs, and I'm not saying that shouldn't happen, But, I would raise a question, are we also, or, are these lawyers also scrutinizing and examining other policies and practices that may be unfair to people who have historically been disadvantaged in the workplace?
Thanks, Jen. And I wanted you to see Suba and Emma, no need to have to come off mute, but if you had anything that you wanted to add to either of the points that Sunu or Jen had made just now.
Nothing for me.
Nothing for me. Great response.
Thanks so much. So we have about another minute or two. If anyone wants to add, I'll give folks another minute to add any questions to the Q&A function or via the chat.
I can add one point while we're waiting for a question
Yeah.
that I heard out recently on a webinar that I thought was very compelling. And that's one of the major costs for employers is turnover. And many employees are looking around for where they can move and change and grow. And one of the things that they're looking for is what is an employer's commitment to DEI when they're deciding between different jobs. And I think that is really a compelling fact to keep in mind as an employer, because in addition to making sure that all your programs comply with the law, you want to save costs and you want to keep employees and keep people with experience and keep excellent people at your organization. And so the more you are doing on DEI and inclusion, the more maybe employees will want to stay at that organization.
Thank you for that important plug and reminder, Sunu. That's such a valuable point. So I just want to mention that our speakers have generously shared their email addresses. They are on the screen. So if you have questions for them or would like to follow up on any of the resources that they shared today, of course, look in the chat because many of them have been posted there. But they have generously offered for you to get in touch with them if needed. And of course, the resources will be included in the slides that go up on our website alongside the recording. I will wrap us up because we're almost at the end of time. Danny, if you could take us to our last slide. So in a moment, I'm going to ask Danny to launch our final poll, which is a survey about today's webinar. It's really helpful to get your feedback, so we make sure that these webinars are always responsive to your all needs in the legal network. Also, if you are not already a member of the Legal Network for Gender Equity and are in our audience, please do consider joining or sharing that link with others who you think would be interested. And as always, you are welcome to follow us on social media. And I want to thank our fantastic presenters, Jen, Sunu, Emma, and Suba. Thank you for all the time and thought you put into preparing for this webinar and for your presentation today. Thank you for the critical work that you do to protect people's civil rights. Thank you so much to Danny, who has just been incredibly essential in making sure that everything worked technologically. Really appreciate all of your support, Danny. And if you could launch that last poll so we can get everyone's feedback on the webinar today, we would really appreciate it. And again, of course, this is anonymous and optional. And we'll leave this up for a few minutes. And I just wanted to respond to the question in the Q&A. Unfortunately, we are not offering CLE credit today for the presentation.
Oh, thank you, Lizzie. Are you gonna do like a screenshot? I never know how to do that. Just give us a warning. Suba, where are you based?
Right here in DC.
Oh, okay, nice. Okay, great. It's nice
Yeah.
to meet you.
Nice to meet you as well. I think I ran into you on the street with, so I work with Laura and Corey, and I think we ran into you in Chevy Chase.
Oh, that's so funny.